Good afternoon. Today I am going to look into the codification of the civil law. Okay. So before we look into the codification, let's understand what civil law is and what are the common characteristics of civil law. So an important characteristics of the civil law is, aside from its origin from Roman law, it is a comprehensive codification received Roman law, that is inclusion in civil codes. So the earliest known of the code is the Code of Hammurabi, and it was came from Babylon, and it was during the 18th century BC. Now, however, this and many of the codes that followed was many lists of civil and criminal wrongs and their punishment. The codification typical of modern civil systems did not first appear until Justinian Code. So, the Germanic codes appeared after 6th and 7th century to clearly delineate the law and the force for Germanic privileged values versus their Roman subjects and regulate those laws according to the folk right. So, under the feudal law, a number of private customs were compiled, and a lot of Roman Empire then elsewhere to record the memorial and the regional customs codes, decisions, and the legal principles undermining them. Then there were customs accomplished by the lords. Then there were these customers were influential towns to soon become over commonplace over large areas. With this, certain monarchs consolidated through kingdoms by attempting to compile them. And the concept of the codification was further developed during the 17th and the 18th century. So, as an expression of the both natural and the ideas of enlightenment, the political ideas of that era were expressed by the concept of democracy, protection of property, and the rule of law. Also, the notion of the nation state implied recorded law that would be applicable to the state. So there was a reaction to law codification. The proponents of the codification regarded it as conducive to certainty, a unity, and systematic recording of the law, whereas its opponents claimed that codification would result in the classification of the law. So, in the United States, the codification began with the New York Fields Field Code, and in Japan, it began in Meiji era. Also, some authors consider civil law the foundation for socialist law used in communist countries. Now, several civil law mechanisms seem to have been borrowed from the medieval Islamic Sharia and fiqh. For example, like the hundi underlies the avalo of the Italian law and the aval of the French and Spanish law. So, I hope you understood what it actually means. Thank you.